Then he said, as you may remember, when I filed your first Rule 32, the 1-year time limit had almost expired. So let me get this straight. According to the state of Alabama, your constitutional rights have an expiration date. And if you find out after their imposed 6-month, 1-year time limit, which you couldn't have found because the jury voir dire had never been transcribed. So how are you going to prove juror misconduct when you don't even know what they were asked the day of jury selection and you don't know what the jurors said as answers or didn't say? But somehow you're supposed to figure all this out as a layperson and file it timely. The attorney said, there's no question in my mind that there has clearly been a constitutional law violation when the juror lied during the voir dire. However, the limitations are as follows, and goes on to quote statutes and case law. And then he says, what the above basically says is that there is a 1-year statute of limitations for filing claims of a constitutional violation. However, the statute states that newly discovered evidence claims can be filed within 6 months of the date of discovery, which I will say they did. From the date of my report, this was filed timely by Attorney Appel. Then he said, now you may ask why this is not considered newly discovered evidence. Newly discovered evidence is described as evidence that could not have been discovered at the time of trial or in time to file a Rule 32 petition that would have changed the outcome of the trial. Clearly, this could not have been discovered before trial or in time to file a Rule 32. However, this discovery does not show that the outcome of the trial would have changed. How are you supposed to know what the outcome would have been had foreperson Ashley not been in that deliberation room? Because you can't talk about deliberations. In fact, you could call all the jurors up and they could sit there on the witness stand, and they still, to this day, would not be allowed to discuss what was said during deliberations. You don't know, we don't know, if her being in that room had any impact whatsoever on the verdict. We don't know. Neither does the state of Alabama. Neither does anyone, except foreperson Ashley. Then Attorney Appel said, I know all of this sounds crazy and totally unfair. Yeah, you think? I think we have a valid argument that this provision of the Alabama statute is unconstitutional. The argument is that your constitutional rights were violated and you were denied a fair trial by an impartial jury. It's just like newly discovered evidence, and you should have a right to raise this issue when it is discovered, as we did in your case. Now we have 1 year to file an appeal in federal court. More deadlines. He said, I know this is complicated and bad news. However, I do feel you have a fighting chance on the constitutional argument. I'm in the process of filing this argument. Let me know what you think or if you have any questions. Okay, so sorry, folks. Your constitutional rights have an expiration date as far as the state of Alabama is concerned. And I'm not an attorney, so I don't know if other states implement the same gobbledygook statutes and time limits where if you find you have a constitutional right to something that was denied you, you can't necessarily raise it when you figure it out because you are now time barred. How is that legal? How is that lawful? How is that unconstitutional? That is unconstitutional. This is what Attorney Appel filed on April 27th of 2021. He filed it with the Court of Criminal Appeals of Alabama. I'm just going to read pieces of this. He said the appellant's mother discovered that one of the jurors had lied during voir dire on a significant and relevant point that went to the heart of the appellant's defense. A second Rule 32 petition was filed on March 9th, 2020, alleging a violation of the United States and Alabama Constitution based on jury misconduct. The state filed a motion to dismiss and the appellant filed a brief in support of his Rule 32 petition. The trial court denied the petition on December 16, 2020. The dismissal order was as follows. Based on the foregoing findings and the conclusion of law, the court hereby further finds and concludes that the pending petition is due to be summarily dismissed. The court therefore hereby orders that said petition is dismissed. The notice of appeal was filed on January 21st, 2021. This is some of the statements of the facts that the attorney wrote. The appellant alleged juror misconduct in that one of the jurors, who became the foreperson of the jury, had lied about prior experiences that she, her best friend, and the mother of her best friend had experienced prior to the trial of appellant. These experiences were never disclosed during voir dire, although specifically asked by both the state and the defense. The appellant was accused of molesting his own son. He vigorously denies this allegation, and the basis of his defense was that he and the mother of the child were in a toxic relationship, and that the mother had coaxed the child to make these false allegations. Both sides were thus clearly interested in determining if any potential juror had experienced a similar toxic relationship in their lifetime, or a family member or friend. The appellant provided undisputed evidence that one of the jurors had gone through a turbulent divorce just 1 year prior to the trial of the appellant, in which her husband had been harassing and threatening her. She received a restraining order against him. Similarly, her best friend had received a protection from abuse order from the father of her child. And in addition, the mother of the juror's best friend, who considered the juror as one of her beautiful babies, also had a violent relationship with her husband, her ex. The appellant's mother heard about jury investigations on the internet approximately 6 years after her son had been incarcerated. She was aware of the jurors' names, but not what they said during voir dire, because there had been no transcription of the proceedings. And we were able to get that. The appellant did not find out that there had been juror misconduct until more than 1 year after his direct appeal had been denied by the Alabama Supreme Court. It was not until the voir dire examination by the state and defense had been transcribed and a team of jury investigators determined that the foreperson of the jury had lied about critical questions posed to her in the voir dire examination. Specifically, the case against appellant dealt with an allegation that he had molested his own son. An allegation, I will say, that he continues to deny, and that no facts support. The defense was told that the appellant and the mother had been in a toxic relationship, and the mother had coaxed the child to make false allegations against the appellant. It was undisputed that the juror had lied by failing to disclose this in the voir dire, that she would have been excused for cause or at a minimum removed as a defense strike. Allowing her to remain on the jury clearly deprived the appellant of due process of law. If the Rule 32 statute is interpreted to deny a person the right to bring a claim within 6 months of discovery concerning juror misconduct, because that discovery was not discovered until more than 1 year had passed, then that is an unconstitutional denial of due process in Alabama. Yes, I would agree. The forewoman had lied during the veneer questioning by failing to answer in the affirmative of direct question as to whether any prospective juror had undergone a similar experience to ones that were suffered by the juror's best friend, her best friend's mother, and herself. It was, of course, impossible for the appellant to know this at the time of trial, that the prospective juror was lying by omission. By the time the lie was discovered, the initial post-trial procedures had been exhausted. The result of all this domestic uproar on Juror Ashley, her best friend Jamie, and Jamie's mother was clearly very prejudicial to the appellant, because the failure of Juror Ashley to answer the questions deprived appellant of information necessary to exercise his preemptory challenge or for cause. As I've said many times, I'm not an attorney, and I've left out all of the gobbledygook language that I don't even understand. But this I felt was important. It said the Alabama Supreme Court has set out 5 factors that have been used to determine whether probable prejudice existed as a result of a juror's failure to disclose. 1. The temporal remoteness of the matter inquired about. Check. 2. The ambiguity of the question propounded. Check. 3. The prospective juror's inadvertence or willingness in falsifying or failure to answer. Check. 4. The failure of the juror to recollect. Check. And 5. The materiality of the matter inquired about. Check. In the present case, it is without dispute that the appellant has fulfilled all 5 factors. First, the appellant's trial began on August 11th, 2014, and foreperson Ashley's petition for divorce was filed on September 18th the year before with the affidavit alleging harassment and threats from the husband. This time period was only 11 months prior to the voir dire questioning. Further, foreperson Ashley's best friend Jamie filed her complaints of threats in 2011 and 2012, a mere 2 to 3 years before the appellant's voir dire. This is not something that happened to them years ago that they blocked out and couldn't remember. This would have been very fresh. Like I said, foreperson Ashley was still going through it. Second, there certainly could not be any ambiguity of the questions propounded by both the state and the defense. During the voir dire, 2 prospective jurors spoke up about problems they had experienced. One spoke of an incident where a man came to her home, bashed in her car, threatened her and her daughter. This resulted in 3 charges of domestic violence against the man, and a protection from abuse order was issued. A second prospective juror spoke up about a patient of his who had injuries he suspected were a result of domestic violence. You know how that ended. And then the third that talked about watching his mother get beat up all the time when he was a child. And again, he was a child and he remembered this. These instances of abuse, claimed abuse, were fresh. Further, defense attorney addressed the veneer, including foreperson Ashley, as follows, and I'm going to quote again because I think it's important to reiterate what she was asked. It is inconceivable that Juror Ashley could not have recalled, since the incident involving herself was less than a year prior to the voir dire questioning. It is without rational dispute that the questioning by both the state and the appellant was material. The appellant's entire defense was that the appellant's and the victim's mother were in a toxic relationship. The inquiries made by both the state and the appellant went to the heart of the defense by appellant and the case the state presented to convict the appellant. Juror Ashley's silence to these questions that she needed to answer deprived the appellant of his constitutional rights to a fair and impartial jury. In this case at bar, the juror herself, her best friend, and her best friend's mother had all been victims of abuse and of abusive men in their personal lives, requiring, in the case of the juror and her best friend, injunctions to halt or control the abuse. It would be improbable that the forewoman of the jury in the instant case could have been indifferent to the result of the suit in the instant case. Does she have an agenda? Well, I think so. What do you think? The charge against appellant in the instant case is sexual abuse of a child less than 12 years old. He pled not guilty. Contrary to Chris's case, Juror Ashley had a history of her own domestic violence. Her best friend had such a history. It was so severe that the intervention of court orders was required to control it. And her best friend's mother, who had sort of taken Juror Ashley as her own, had suffered domestic abuse. By her silence, she concealed these events. If Juror Ashley had truthfully answered the voir dire questions asked by counsel for the state and the appellant, which were designed to elicit information about domestic abuse, she would have been struck for cause. No doubt. At the very least, she would have been a preemptory challenge. The mere fact of her silence in response to the direct questions from counsel asking about domestic disputes in the jurors' past showed that she knew she was dragging into the jury where they did not belong the bitter domestic past of her and the woman she cared most deeply about. The two women. She more than met the Drennan standard that she would probably have been prejudiced. She no doubt suspected that if she gave truthful answers, she would not be allowed to sit on the appellant's jury. Now see that. Now you've hit it. She knew. She knew exactly what she was doing, in my opinion. All of this brings our consideration to what the Alabama law provides when prospective jurors do not truthfully answer voir dire questions and thus conceal crucial information needed for a fair trial by fair jurors. We began by pointing out the fact that whereas here, there is no way for trial parties to discover the truth in the fact of juror silence, parties are allowed 6 months after they discover, if they ever do, juror dishonesty, which shows they did not have an impartial jury. It is perfectly clear that under the Sixth Amendment to the United States Constitution, made applicable to the states through the 14th Amendment, that requires a unanimous jury verdict, one partial juror can defeat a unanimous verdict by impartial jurors. If you don't think so, watch the movie Runaway Jury. This will convince you. I know it's Hollywood, but it will convince you that that is true. I was a four-person. If I said, let's vote guilty and go home, that's exactly what would have happened. The keystone of all considerations of impartial jurors is some procedure whereby parties can catch jurors who refuse to answer truthfully the voir dire questions asked of them. As a practical matter, silent jurors cannot be caught lying during trial. There must be a way that parties can catch such jurors after trial and still correct the injustice of being tried by partial jurors. The Criminal Trial Rules of Alabama provides such a device. Rule 32.1, Alabama Rules of Criminal Procedure. This rule provides that subject to the limitations of Rule 32.2, any defendant who has been convicted by a criminal offense may institute a proceeding in the court of original conviction to secure appropriate relief. The Sixth Amendment to the United States Constitution requires that a defendant in a criminal trial is entitled to trial by an impartial jury. But how is that right enforced if a particular prospective juror does not truthfully answer questions in the jury selection process? And how are you supposed to know? They take an oath, they swear to tell the truth. No one has the time to assume that people lied, and let's figure out if we can prove it before the trial's over. That's absurd. In Alabama's normal jury procedure, the names of prospective jurors are not given to counsel until right before the prospective jurors are brought into the courtroom. What? Did you catch that? So you don't have to rewind it. I'm going to say it again. In Alabama's normal jury procedure, the names of prospective jurors are not given to counsel until right before the prospective jurors are brought into the courtroom. This means that counsel is dependent on the prospective jurors answering honestly the voir dire questions designed to test the prospective jurors' biases and prejudices. Since the striking of the jury normally takes place immediately after voir dire, there is no way to test the honesty of the prospective juror's failure to answer before striking the jury. And aren't criminal defense attorneys supposed to be trying the case during trial? I believe that's their job, is to be paying attention and to be defending their client, not over there on a laptop looking up social media posts and digging in. And even then, as we've said, well, I didn't say it, I'm going to say it. These are some of the other exhibits that we found: petitions for divorce, protection from injunctions, or protection from abuse injunctions, and the police reports. How are you supposed to petition and get all of that before trial's over? Well, you can't. It's impossible. Criminal and civil defendants have Sixth Amendment rights to an impartial jury that must be respected under Alabama law. The right to a jury trial in criminal cases is protected by the U.S. Constitution, but the right to an impartial jury is in the 14th Amendment. The voir dire is designed to give the defense and the prosecution the opportunity to inquire into possible grounds of bias or prejudice that potential jurors may have. Now, why is it important when someone speaks up about something and then someone doesn't? Well, because if you don't speak up, you deny the state and the defense an opportunity to find out how you feel about that. The Alabama test is probably prejudicial, not actually prejudicial. I might add that in Florida, you have to show actual bias, which, in my opinion, not a psychologist or a psychiatrist or a physician in any manner, I have no alphabet soup after my name. But how are you supposed to know if someone is actually biased? You can't read their mind. All you can do is listen to their words, watch their language, watch their body language, and look at the results of their behavior. That's the only way I know to prove that someone is biased or prejudiced. You can't know that by simply listening to their words. This standard calls for the application of common sense. Does the answer to a question that should be answered in the affirmative become a basis for reversal of the jury's verdict of guilty? The answer to this question may be, in what reason would a juror have after taking an oath to answer all questions honestly and then refuse to do so? The most logical reason is that the prospective juror wants to serve and is afraid to answer certain questions truthfully because that answer might result in them being removed from the jury. Amen to that. So it is with the jury forewoman in this instant case. She and women to which she was close to had suffered enough from domestic violence. But here was a chance to strike back at that evil. The partiality of the forewoman is clear. The conviction must be reversed. The probability of prejudice and the denial of an impartial jury is just too strong. Rule 18.4b, Alabama Rules Criminal Procedure, provides that the oath of prospective jurors provides as follows. This is the oath that the jurors take prior to answering the questions during voir dire. Do you and each of you solemnly swear or affirm that you will well and truly answer all questions propounded to you touching on your qualifications as a juror, and that you will well and truly try all issues submitted to you and true verdicts rendered according to the law and evidence, so help you God? Foreperson Ashley said yes to this and then lied. On the next to the last page, Attorney Appel wrote in big capital letters, any statute of limitations denying a person the right to litigate constitutional law violations without a saving period is unconstitutional. When there are violations of clearly established constitutional rights, then just as in newly discovered evidence, which this was, the defendant should have a right to litigate those issues within 6 months of the date of discovery. Any statute that denies such a right is unconstitutional and should be set aside. The appellant has undisputed evidence that the foreperson of the jury had lied during voir dire concerning critical questions. While incarcerated, his mother hired a jury investigations team that uncovered the lies of the juror, but it was not discovered until more than 1 year after the first appeal of the appellant had been made finalized. The failure to allow the appellant to prove this undisputed evidence denied him due process and is unconstitutional. If this procedure is allowed to stand, then verdicts with jurors who are statutorily unqualified to serve on a jury or who have lied will be able to render verdicts, and if they remain silent, the verdicts cannot be attacked. This travesty should not be condoned by our courts. So, Beautifully said. What happened? Christopher's still in prison. I have something that I framed today because I had someone else bring this up during a conversation, and I thought that was interesting. You've probably heard this phrase: better that 10 guilty persons escape than one innocent suffer. Now, this is attributed to Sir William Blackstone from 1765. Where's that judge? Where are those judges? Denied, denied, denied. We have a potential client that I've been working on his case this week. And when I got to the end of the jury voir dire, this struck me so odd, I thought I would bring it to your attention. The judge said to the jurors who had been chosen a couple of things. Number one, we've had the opportunity at this point to give each of you those lovely red, white, and blue buttons that say jurors. I want you to do me a favor and wear them while you're in the vicinity of the courthouse. Now, they're red, white, and blue, not for the patriotic value. Oh, of course not. But they will go good with anything in your wardrobe, so it looks good on you. My definition of the courthouse vicinity is from the moment you get out of your car in the morning until the moment you get back, and the reason is really very simple. You are going to find that this newfound status of yours as a juror is going to result in no one around this place talking to you because they can't be certain whether you're participating in a case. That is why you need to wear it. It avoids problems. You know that when you came in this morning, you came in from the garage. There's a lot of room for people to interact with all of you. And lawyers and witnesses, as they wander the halls, just have this great habit of talking without necessarily thinking about the surroundings. So, by wearing these buttons, you are telling everyone in the courthouse you're probably first a juror, and secondly, that they really ought not to be discussing things around you, especially on the elevators. So, be very, very careful. And if you hear anybody talking, you just turn around. Tell them that you're a juror and that you'd appreciate it if they would carry their conversation someplace else. And if there's a problem, you take names. You tell my bailiff, and I assure you I will deal with them. It's a game show. Well, what's all that? Is that how jury foreperson Ashley felt? That she was elevated to this status of eliteness? You know, the jury's in charge of the verdict. The jury decides the fate of the accused. So, would you want somebody on your jury who lied and actually was going through it, but didn't want to say it because they wanted to make sure to stick it to you when they got in that room? What if? What if all of these accusations against Christopher are false? What if, and again, I am not commenting on the case, and I don't want you to take any of this as my explanation of what happened because I don't know. I wasn't there. I didn't live in that house. I don't know what happened between Chris and his son's mother. I just know that it went horribly wrong, just like it did for Martin and his wife. So what if the son's mother decided that she didn't love him anymore and fell in love with someone else? What if? What if that person decided that he liked your little boy and he wanted him to be his? He wanted to raise him. He wanted to give him his last name. What if the only way for that to happen and them to live happily ever after is to get rid of you? I pray to God that you aren't going through something like this and that you don't know of someone who has. But I do. I live with one. I understand how easy it is to be falsely accused because somebody has an agenda that does not include you anymore. How many times have you heard about somebody that everything was rainbows and unicorns? A few years into the marriage, it went horribly wrong, and they decided they didn't love you anymore. They loved someone else. You have a small child, and they don't want you to be around that child anymore, and they also know that that child is a trophy. They can win that child in the divorce, but to do that, they're gonna have to make up something. And when a kid is 3, 4, 5, 6 years old, it's very easy to put thoughts in their head and put words in their mouth that aren't true. That child has no idea that he is about to say something that is gonna cause him to lose his daddy and his grandma. What if? What if that's what happened? And then this person comes in there and decides you're guilty. Doesn't know anything about you or your situation, but based on what they are going through, has decided that they're gonna make sure that you don't get to raise a little boy. What if? Did Chris get a fair trial? No. Did the state of Alabama fix it? Course correct it? Hold this lying juror accountable? No. Sometime later, Chris's mom found out that there was a custody hearing in the judge's chambers, showed up to the courthouse, was not allowed in, had to sit outside. And even though she was there to fight for her grandson's name was changed, and he was allowed to be adopted by the new guy. Christopher has been beaten literally within an inch of his life. We didn't think he would survive it. I won't say by who. Prison is a horrible place. All because somebody decided they wanted to keep everything but you, but him. Thank you for being a part of this today. Thank you for listening. Thank you for watching. If you know of someone who's going through it or has been through it, could use our help, our contact information is in the description below. Remember, the courtrooms may be silent, but we won't be. So speak up, speak out, and always speak the truth.